Microphones are coming up. Welcome to the regular meeting of the City of Bethlehem Zoning Board. My name is Peter Schneck, and I'll be serving as chairman this evening. Serving tonight along with me is Sharon Wiles-Young and Lucas Walk. Our zoning officer and tonight's secretary is Dave Taylor. Our solicitor tonight is attorney Steve Boel. Stenographer tonight is Moira Evans. At this time, if there's any members of the audience who might have testimony or have questions or comments, please stand to be sworn in.
On either application.
Raise your right hands. You do swear or affirm that the testimony which you shall give in the matter now before this board shall be the truth, the whole truth, and nothing but the truth. You do so swear or affirm?
I do.
Thank you.
For the first appeal, which is 436 First Terrace, it's a continuation, so I'll just
Yeah.
hand
So,
it.
getting there. Oh, sorry.
I was going to say hand it over to attorney Steve Boel for some housekeeping.
So as everyone may recall, that the application for 436 First Terrace has been the subject of two prior hearings. And at the conclusion of the last hearing, the evidentiary record on that matter was closed, which means that we're no longer taking factual testimony. At the last hearing, the board set a briefing schedule for proposed findings of fact and conclusions of law, and the board received those from counsel to both parties. We thank them for those. The board reviewed them carefully, and we appreciate that. The reason we're here tonight is for the limited purpose of closing statements and legal argument from the parties of record. We're going to start with Attorney Raschuti, where he can make his closing statement and make any legal argument. The board knows that if they have questions, they can certainly raise those questions as a part of that. At the conclusion of both arguments, the board may also have questions. Is there any members of the general public that are here that were given party status at the last hearing? If they want to make very brief closing argument as well, we will also allow that. But I want to make very clear that the evidentiary record is closed. This is solely for parties of record to make legal argument. So just general argument about facts and things like that. The board received the comments previously. We appreciate them, and the board understands that. It's tonight just legal argument. And as we have discussed, one of the council has an immediate commitment after this. What will happen is that the board will close argument relative to this matter once we're through all of that, and they're going to delay action on that until the close of tonight's meeting. There's another application that will be heard. The board wants to have time to deliberate. So at the close of this hearing, they will go into both hearings. They'll go into executive session, deliberate, and they will come back and act on that most likely tonight. We believe tonight. It will be tonight. So with that, Attorney Raschuti, I turn it over to you.
Thank you. First, thank you for your time and attention throughout these hearings. I know it's not easy. It's difficult sitting here sometimes listening to testimony over and over. So I appreciate that. At the end of the day, this case comes down to a very simple question, in my opinion. Can the city regulate a property as a student rental property for years, collect fees, conduct inspections, prosecute violations, expressly recognize the use as lawful, and then suddenly claim the use never existed at all? That answer should be no. The evidence established that my client purchased the property in 2019 before the student housing overlay ordinance was enacted. At that time, up to 5 unrelated persons could legally reside together at the property. From the time my client acquired the property, the city allowed it to be treated it as a regulated rental property. The city accepted registrations. The city accepted fees. The city conducted inspections. The city issued inspection reports. The city issued violations under Article 1739. The city even obtained judgments based on those violations. The city's entire course of conduct recognized this property as an RRU student rental property. Most importantly, in June of 2025, the zoning officer himself reviewed the records and formally determined that this property was a legally non-conforming student housing use. That determination was based upon city records, permit history, inspection history, and the information in the city's possession. Only after my client sought approval to expand the use did the city's position suddenly change. The city now argues there was never a use because students never physically occupied the property. But that argument ignores the reality of what occurred here. The prior owner remained in the home because she was seriously ill. My client made the humane decision not to remove her. During that time, my client registered the property, paid the fees, marketed it as a student occupancy, communicated with prospective student tenants, maintained the property, and prepared it for that intended use. That is not abandonment. That is not forfeiture of that use. That is not the property owner walking away from a use. That is a property owner doing everything possible to preserve the student housing use. Even the city's witnesses acknowledged that failure to pass an inspection or maintain a license does not itself destroy a lawful nonconforming use. The board heard no evidence that my client intended to abandon this use. In fact, every piece of evidence points in the exact opposite direction. The city wants this board to conclude that a use it regulated for years somehow never existed. The record simply does not support that conclusion. The more reasonable conclusion, conclusion supported by the city's own actions, its own records, and its own June 2025 determination is that the property was established, recognized, and regulated as an RRU student housing use prior to the overlay ordinance, that the use was never abandoned, and that the requested expansion satisfies the requirements of the ordinance. Accordingly, we respectfully request that the board reverse the October 14th, 2025 determination, recognize the lawful non-conforming status of the property, and grant the requested special exception relief. Thank you.
I don't believe this microphone is working, so I don't think the millions of people watching will be able to hear me, but hopefully you can.
Okay.
Just speak up, Matt.
Just speak.
Some people are indeed watching.
It was on earlier.
It's important. It's important. that
You want this?
residents-
We're getting on a mic.
Or that.
We hear you.
Or that one, Lucas.
Reach.
I was gonna say, can we take yours and move it over? Could you do it from there? I don't take away from your materials. I mean. If you don't
Stand
mind.
at the podium. That microphone work? Throwing it out there for you.
All right. We're good? Okay. All right. So on behalf of the city, I think it's important not to get distracted by distractions. The focus here, the primary issue here is, was there a non-conforming use on the property when the ordinance was amended in 2021? Remember, the applicant, they're seeking two types of relief, special exception and a variance. To focus on the special exception, it's a special exception to expand a non-conforming use. So under the law, to get a special exception, you have to show that the applicant has a burden to show that they can meet these specific objective criteria of the special exception. So to expand non-conforming use, one of the specific objective criteria is that there be a non-conforming use on the property. What's a non-conforming use? I hashed this out in great detail in my brief. The applicant really doesn't address this, not surprisingly, because there is no non-conforming use on the property. So the definition of a non-conforming use is a use, whether of land or structure, which does not comply with the applicable use provisions in a zoning ordinance or amendment heretofore or hereafter enacted, or such use was lawfully in existence prior to the enactment of such ordinance or amendment, or prior to the application of such ordinance or amendment to its location by reason of annexation. The case law is clear. The benefit of legal non-conforming use status is available only for the lawful use which existed on the land when the ordinances took effect, and it is the burden of the party proposing the existence of such non-conforming use to establish both its existence and legality before the enactment of the ordinance at issue. In order to establish a prior non-conforming use, the landowner must present objective evidence demonstrating that the subject land was devoted to such use at the time of the enactment of the zoning ordinance. So I would ask all the members of this board, where is the evidence that this property has ever been used as a student home? That is to say, 3 to 5 college students. Where's the evidence that the property was ever used as a regulated rental unit, meaning 3 to 5 unrelated individuals? The applicant's own witnesses acknowledge that the property was never used that way. Never, ever, ever used that way. The references to how the property was treated in the city records is a red herring. That doesn't establish use. The use is what you make of the land. You use your homes, you cook there, you sleep there, you watch TV there. It doesn't depend upon what may be reflected in the city's records. That's the use of your home. That's the use of a residence. This property was used as a single-family residence prior to the enactment of the Student Home Overlay Ordinance in 2021 and after the enactment of that ordinance. It was compliant pre and post enactment of the Student Home Overlay Ordinance. Given that, that's the ball game. It never had non-conforming use status because it was always compliant. It had one resident living there, which was a family under the zoning ordinance. That's all we need to show. Because there's no non-conforming use, you can't expand that which does not exist. To address some of the other arguments of the applicant, the only reason why, again, this doesn't matter. It doesn't matter what's in the city's records, and the applicant has cited no case law, no principle of law, which would say that this does matter. But even if it did, remember, the reference to the RRU in the city's records, and was never a reference to a student home, only an RRU. It's only because the applicant made a representation to the city in 2019 that they sought to use the property for an RRU. The reason that that designation got burrowed into the city's records is because the applicant put it there, and we never changed it because we never had reason to. That's what the applicant represented to us. That was the practice of the city to continue on with that designation until we were told to change it. The applicant makes a lot of issues about how the city performed inspections. The applicant applied for and paid for the inspections. So the city went out and inspected the property. This isn't a situation where the city somehow delayed or inspected the properties in such a way that it eroded or deferred decision on the non-conforming use issue, right? It's not like the applicant applied, say, a day before the Student Home Overlay Ordinance went into effect, and the city, or even before that, let's say, and the city deferred inspection just to defeat the application for the student home zoning permit, right? There's been no argument whatsoever that the city acted improperly or delayed the inspection. In fact, the applicant's witnesses testified that the city was unable to get into the property because Mrs. Borso or Ms. Borso was living there and impeded access. There's been no suggestion that the city's findings in the various inspections that the property was unfit for occupancy and unfit to have issued a certificate of occupancy was somehow an error. There's been no dispute that the violations that were existing on the property weren't actually violations. So if we take the fact that the city inspected appropriately and at the behest of the applicant, we also have established that the property was never able to be occupied as a regulated rental or a student home. So there was no possibility that it could be lawfully used as a student home. But lawful use or not, I come back to the original issue. There was no use. We have to establish the use first. And to say that the city treated it this way only at the behest of the applicant itself doesn't cut it. There's no use of this property as a student home. That's the ballgame. You can't expand that which does not exist. The other request for the variance, and I would just say a few other things on this. So the marketing of the property that the applicant talks about here, remember, that occurred after the student home amendment was passed. So the fact that the property was marketed for students after the amendment was passed is irrelevant because, again, the use has to be in existence before you make the ordinance change. Regarding the variance, again, the property had been utilized as a single-family residence with the one resident both before and after the student home overlay amendment was enacted. The applicant's witnesses themselves testified that they could make use of this property as a single-family residence. That is to say, with a mom and dad, 2 kids, with 2 unrelated people, with 1 person. It may not be the most lucrative use, but that doesn't matter for a variance. If they can make use of the property as a single-family residence, then there's no hardship to do so. So on that basis, the variance should be denied. And like I said before, the special exception should be denied. I'll say this ad nauseum because there was no non-conforming use ever established. Thank you.
So Matt, if you can hang out there just because
Sure.
questions. So let me just tee this up for the board this way. So we're going to have to make these motions later on. And I want to make sure the way that I'm going to have the board approach this makes sense to both council. So question number 1 that the board needs to vote on is whether or not there was a lawfully established pre-existing non-conforming use for student housing. That's question number one. Question number two is if the board, actually take a step back, if the board finds that there is not a pre-existing non-conforming use of student housing, the board needs to move on to the variance question. Is there a variance? Did the applicant meet the legal burden for a variance? So I think that part's pretty straightforward. If the board finds that there was a pre-existing non-conforming use of student housing, the board would move on to the question of abandonment, which is, was that pre-existing non-conforming use abandoned? Both of you capably briefed that issue. If the board finds that it was abandoned, then they move again on, my understanding is they again move on to the variance at that point, right? Because the question is, in the absence of the non-conforming use, did they meet the burden for the variance? If they find that it was not abandoned, at that point, they move on to the special exception for the expansion of the pre-existing non-conforming use. And I like confirmation. I think it kind of ends there, right? There's no variance beyond that because the use has been established. The question then becomes, is there a special exception? Would you both agree that that's kind of the chain of analysis that the board should go through?
I do.
I do. You have your flow chart ready for that?
I genuinely sat down and wrote it out. That there are that many arrows. So with that, then I turn over to the board for any questions relative to that they may have on it.
I'm gonna start.
Sure.
Go ahead.
I mean, I appreciate you both. I think that this has been one of the more confusing cases that certainly I have heard, because I think of the tiny little words that we're trying to figure out, right? The legally existing use and so on. I really put a lot of thought about this today, and I tried to take the strong feelings of student housing that the city has out of it, and I thought about it in terms of a restaurant, right? And if I open up a restaurant and I pay the fees and I pay the inspection costs, but I never actually pass a CO, 5 years later, do I still legally have a restaurant? So I'm going to ask that to both of you. Take the student housing out of it. How would you answer that?
I believe, yes, you do have a restaurant.
Yeah, taking the student housing out of it, and I would just talk about this in the abstract.
Of course.
You don't have a restaurant use. If the use is not established by you applying for permits or obtaining inspections, the use is established by the actual use of the property for that purpose. Whether it's a restaurant, whether it's your residence, it's the actual literal physical use of that property. That's what it is. If there's never a use, and I don't think it's disputed here that there was never a student home use. Without making the use of the property in that way, there's no non-conforming use.
Can I respond to that?
Sure.
The city's ordinance predicates nonconformity on having an RRU prior to the enactment. All right. The city's argument is it's not a student home because no students ever slept there. But the use was established, all right, by getting the RRU, registering it as an RRU. And that's what the city ordinance says.
So
If
let
you
me-
want to keep your non-conforming student home, you have to be registered as an RRU before.
was
Doesn't
it
say
ever,
you have to have students in there.
was it ever actually cleared as an RRU? Did you ever actually get a CO? Like, did you ever actually pass inspection? Any of those inspections?
I don't know the answer to that. I don't believe so, but I don't know the answer.
Well, I mean, if I can respond to that.
Yeah, go ahead.
I mean, we put in all the inspection reports. They never passed inspection. They were never cleared for the CO. And also, this is important, not only was the property never used as a student home, it was never used as an RRU. There were never 3 to 5 unrelated adults living there. There was always that one person living there. And that is a family, a single family under the zoning ordinance.
So the question I was going to ask to follow up on that, because you actually raised the point that I struggled with, is the zoning ordinance speaks in terms of a zoning permit, right? I mean, that's the permit that's issued usually under the zoning ordinance. And it says that may fall under an application for a CO. Is there any differentiation between the RRU application and a zoning permit?
think the issue there was no zoning permit required in 2019 to have students in your house. You needed an RRU permit. I think Matt would agree with that.
I would agree. I would also agree that none was ever issued.
Yeah, but to your point, Attorney Raschuti, you're saying that other RRUs just filled out that application. They did not have to file for a zoning permit.
And yes, and just to further the point, there are student homes in Bethlehem that were existing in 2018, 2017, 2019 that maintain their RRU and may not have students in that, but they can go back to student uses because they've maintained their RRU licenses. And I've know the city has dealt with these in the past. So I think it's, that's one of the things. We think that use has been established by requesting the RRU. I don't think occupying the beds matters. That's the question that the board will have to decide. I think is really when that use was established and read into, I think the student housing overlay as it stands now. To keep that, you need the RRU.
Sorry, Luke, so you have more?
I mean, if I'm just, I'm not going to lie. I do struggle with the fact that the city has taken the fees, has done the inspections. There's 2 RRU ordinances on 124-25 and 730-25 that were summons that were given, that were provided to us. So it's tough. This is what I said. We go back to that term lawfully established. And I think what I struggle with, and I'm not sure if I've been fully convinced, to be completely honest, being legally lawfully established, it seems like to me that the city has been referring to this unit as an RRU. And I understand your point in saying you don't have kids in the beds, but I also understand the point in saying you don't have to have kids in the beds because we've done this for 5 years, right? But I think that we're talking about a pretty long timeline, right? That no inspection was ever passed. I understand, but I go back to, once again, my restaurant analogy. If I applied to open a restaurant in my house and then made no clear actual argument or push to actually put a stove in my living room, I don't know if I have a restaurant 6 years from now. I just don't know. And I'm telling you, that is where I'm struggling. But I don't think it is we have talked about it extensively. I don't think that it can be said that the city should take some responsibility here as well, because no matter what the decision is here, I do not think that it is right that the city continues to take fees, continues to do inspections, and continues to pass these things and give summons for something called an RRU in their words, and then turn around 6 years later and go, whoops, that's actually not true. So I know that that's not a question. I'm just speaking my thoughts out loud, and I'll pass it off to my team.
Okay. I just would like.
Well, so as a question and answer, I think
Go ahead.
I think it would be fair to let council respond.
Sure.
Right.
Okay.
Yeah,
So-
sorry.
I do think it's important there, right, that the reason why these inspections were taking place, right, is because in 2019, the applicant returned the RRU packet saying it was an RRU, and they returned RRU packets in subsequent years saying it was an RRU. So when someone requests an inspection, the city performs the inspection. It's not a seal of approval that the property is actually occupied as an RRU. In fact, to occupy the property as an RRU, you first need to undergo a successful inspection and get your CO. So just because you're applying or requesting an inspection and it's done, that's a service the city provides. You may not like the results of the inspection. You may fail your inspection, but I don't view it as some kind of fault upon the city that when the applicant says it's an RRU, it asks for the RRU inspection. We go out there, we perform the inspection, and they fail. I don't see how it follows that either the city's at fault or that we've somehow, by whatever type of action, and sort of represented that, yes, we actually believe this to be an RRU. Our records reflect that because that's what the applicant told us the use was. But I'm talking about all this. I always like to tie it back to the beginning when I say that it's not enough that you have the records. If the applicant had some kind of case law that said that the records were important, I assume they would have cited it. When you get back to the nuts and bolts, the use of the property was never an RRU, never a student home. only a single person lived there, a single family, always compliant, never non-conforming use.
Can I ask, this might be, I will let you, is that true? Dave, do you need a clear CO to be established as an RRU in the city zoning?
I don't recall with the, and I can look it up in the ordinance, is that you needed to pay the fee and pass the inspection.
So Matt, as a solicitor, I mean, what would your position on that be?
Do you need a clear CO to becoming an RRU?
Yes.
To establish.
Yeah, you recall, because there's a separate ordinance that regulates RRUs and kind of the nitty gritty of it. So you can't put people in there as an RRU until you've passed the inspection under Article 1739. So I would say that that is a prerequisite to having a lawful RRU use.
Even before the student housing ordinance took place?
Yes, because the RRU ordinance was in place prior to 2021, prior to the student home overlay. The student home overlay ordinance, it defined both student home and regulated rental unit in the zoning ordinance. But there was a preceding, or there was an existing ordinance that just dealt with the administration of RRUs that was not a zoning ordinance. And that had gone back, I think you saw even when the Borsos lived there, or when Francis Borso was living there, taking care of his mom back in 2012 or 2014, we still had the RRU ordinance. So yes, you need to pass the RRU inspection to be able to operate the property as an RRU, even before the student home overlay ordinance.
Sir,
Yeah, I mean, are you responding?
Going back to your restaurant analogy, I still think it's a restaurant. I still think in this case, the client's intent, my client's intent to have a student housing rental there and apply and take the steps necessary establishes that use under Pennsylvania law. Whether or not he actually had students there, and I would say it even establishes under what the city has said is a non-conforming use for student housing. Whether or not he has students there actually, it goes back to that. If a restaurant's vacant for a year or two, does it lose its non-conforming status? No. The city's ordinance may say it does, but in Pennsylvania law does not say that, okay? And I think here in this case, the intent was always to have a student housing rental there. There were factors that got into the way, pandemic, sick person. I mean, we've been honest about that. I think you saw she had a lease to stay there after purchase and was supposed to be out. She did die in the house. So I think what I think there is under Pennsylvania law, established uses are protected. I think they established a use.
So my question to follow up on some of your statements about intent, and if there's intent, that is not always meaning use, right? So intended to use, but it wasn't used. And when you gave the example of the RRUs that have been used by students and then they're left and they're now out of the RRUs, but it can go back to it. There were students in there first. So that's what I'm trying to establish here, that really were there any students there? And I know the intent is there,
Yeah.
but that I think is what we're struggling with. I am.
And the testimony freely admits no students have lived there since they've purchased it.
And they could have been in there. 2 students could have been in there.
I mean, 2 students could be in there now
if
they wanted. Yes.
if the certificate of occupancy could have been made.
Yeah, I guess my confusion a little bit is the process, and I'm not sure I agree fully with Attorney Deschler, but maybe the city can answer this. In order to get the RRU designation, somebody has to fill out that flyer. The city goes out, inspects it, and either issues the violations or a certificate of occupancy.
Correct.
Once that certificate of occupancy is in the record, does the city have a tracking system in which it tracks RRUs? Like, how do you know what properties out there are RRUs?
Matt?
Well, I think once you have a CO for an RRU, you're able to utilize the property as an RRU. Now, if for example, you delay, if you got approval, say in 2019, and you just didn't use the property as an RRU until 2022, so after the student home overlay amendment was passed, I would say that you don't have the actual use of the property, at the time of the amendment.
So in your opinion, like, let's say they marketed it for 4 students, a person comes in there and they just want to pay the entire rent themselves, and you rent it to that one person.
One student would be a family, so one student would not be a student home because it would just be a single person. And I would also say that to me, this is very important. This is not a situation where you had a vacant property, someone applies for an RRU license and is just waiting to get it, right? This is a property that was occupied by a lawful use, right? So that's critically important, because if you have a lawful zoning compliant use of the property, you cannot have a nonconformity. And I don't want anyone to lose track of that issue. It's not just that they didn't have students there prior to the amendment, right? What also matters is that they had a lawful conforming use pre and post amendment.
But prior to the amendment, an RRU was lawfully. That was a lawful use, right?
They were, if they got the inspections, but they were using the property as a single family residence with one person.
But an RRU was a lawful use prior to the amendment.
It would have been, yes. I mean, it was if
If she would have left at that point, they could have,
Yes.
before the
Used it.
amendment,
yes,
they could have used it as an RRU.
correct.
Just to clarify, RRU is not a use, and it wasn't a use before the student housing overlay. It's a permit to have 5 unrelated people. It's not even that. It's a permit to have 5 students in the house is really what it is.
It is a use now. It's a use under the
Yeah.
2020 amendment. I agree that it was not a zoning use prior to that amendment.
It was
Separate-
not.
it's now
And that's what I
separately-
stated. Yeah, it was not a
Now
use.
separately defined.
So before the overlay amendment, you could have up to 5 unrelated people living in a house. And that was the definition of a family. That was included in the definition of a family. They've changed those definitions with the
Yeah.
overlay amendment.
But having students in that home prior to the amendment was not a non-conformity. It was a conforming.
It would have been compliant with, if up to 5, it would have been compliant with the zoning ordinance's definition of family.
And just to follow up on that, if they had 5 people in a house without an RRU, they wouldn't have lost their zoning status on that. They would have just been fined under the RRU ordinance prior to the overlay.
I just want to say one more time too, and Matt, I understand the applicant filled out the permit, city inspects it as that. And this is a very extreme example, but this is where like my ethical dilemma comes in. If I fill out a permit to open up a theme park at my house, is the city going to come out and take my money and inspect it to see if I can open up a theme park at my house? Just because I submit my application.
Well, I have to say that I can't deal with that just in the abstract, because I think if someone goes to your house, they can probably see that it's definitely not a theme park. You don't have the roller coasters and the like. Maybe you do, and we might come for you for that. But in this case, right, they go out there. You see it on the screen. It's a house, right? So in 2019, when regulated rentals were allowed on this property, the applicant submits their application packet and it gets into the city's records. If it were an RRU, then the city would have no reason to doubt its continued use year after year when the applicant submits requests for inspections and the city goes out and conducts the inspection. Remember, a lot of the time when the city went out there, it couldn't actually get into the property, as the applicant acknowledged, because of Kathleen Borso being in there. And when it couldn't inspect it, it found violations. The applicant never really contested those violations, and that's why it never got a CO. So I do think your example, I don't think it really maps onto what happened here, because if the city's just going out there and they say, well, look, this guy applied for an RRU in 2019. I mean, if it was an RRU, then it would have non-conforming use status. And yeah, we'll go out there, we'll inspect it, we'll give you whatever the results of the inspection are. And that's what happened. So I don't think the fact that the applicant's representation that this was going to be an RRU should somehow redound to the, adversity of the city here, just because we did what it wanted. We went out there, we inspected it. Yes, we took their fee because they're paying for the inspection. I think that to me that does matter, and that's why I don't think the city acted improperly or unethically. If someone's asking you to inspect a property as an REU, they pay a fee, and what do? You inspect it. I think the city performed that service it received for the fee.
Yeah, so here's my question then, and I know we have time, or we have a time issue. There's the pending ordinance rule, where if I file an application before there's an amendment, and my application is lawfully pending at the time the amendment goes in place, my application is reviewed under the old zoning ordinance, right? I'd never use my use as a restaurant. I'd never use it as a theme park. I'd never use it as student housing. I filed it. It remains protected as long as it proceeds in good faith, is reviewed, and the applicant takes it through the process. That's different than a vested right. I mean, the vested right, and this is your argument, right, Matt, which is your vested right is there must be students in the beds. There must be a roller coaster on the property. There must have been something that was physically present. That's kind of your argument, right?
Yeah,
Matt?
right. I mean, if for example, the applicant had applied for, because this isn't land development, you don't have that section in the MPC that says basically that you have up until the date of the ordinance change where you can submit an application under the old ordinance and get the benefit of it. So I do think in this case, the pending ordinance doctrine would have applied. But I do think to even have the benefit of that, right, the applicant still has to submit an application, right, a zoning application for the use in advance of the ordinance. And
Right. Yeah, go ahead. I'm sorry.
I guess in this case, you never had any kind of zoning application because for any kind of use or use change, because the property was lawfully occupied by Ms. Borso. So that's what I struggle with the applicant's argument that, because it was requesting inspections, that somehow established a use. I think it might be different, for example, if the ordinance was about to change and someone made an application for a use that was going to be excluded by the new ordinance. But that's not what, and let's say the property was vacant and that's what they were trying to do. But that's just not what happened here. I mean, I think if you took that to the logical extreme, you could go back decades and decades and say, well, someone applied for an RRU back in 2002, it always failed inspection, but because it applied way back when, we're somehow carrying that over, into 2021, and they should be awarded some non-conforming use status when they never established the use in the first place.
I have less of an issue with the applications. I have more of an issue with the two violations.
So I was just about to say.
But I guess this is my response to that. And I think I don't get too philosophical as a lawyer, but I do think on this is, to me, this is important, that when any kind of body with authority applies the law, it's important that, right, that they stick to what the text of the statute or the ordinance or the case says, as opposed to, any kind of abstract notions of even fairness or justice. And what I would say about that is that when you say that it matters that there were these violations or citations that were prosecuted by the magistrate, you still have to tell me why that matters in establishing the actual use of the property. If the property was never used, never ever used to house 3 to 5 students or 3 to 5 unrelated adults, and the law requires actual use, the fact that there are zoning, or that the fact that there are Article 1739 violations is just irrelevant. It doesn't affect whether the property was actually used that way.
But are they not?
It's a variance by estoppel issue, right?
But it wouldn't be I think I addressed in my
You
brief.
do.
Right.
You
and,
briefed
and,
that.
and the applicant didn't even raise that argument. But I mean, to get to the variance by estoppel, generally it requires some kind of permit issued, like let's say wrongfully, and reliance on that, which
Yeah,
didn't
but-
happen here.
And I want Mike to respond, but I mean, that's kind of the issue is I think the board's struggling with the city is simultaneously saying it's not a pre-existing non-conforming use, but we issued a citation relative to it.
Well, I think in part that happened, and I still believe that that doesn't reflect the actual use of the property. But what I would say here is if the city's records reflect the RRU status because the applicant submitted RRU packets, then yeah, when the code people go out, remember, the code enforcement is different from zoning, right? They work together, but they're two separate tracks. So if in the Community Plus system, the property is reflected as an RRU because of the applicant's representation, and code people go out there and they see the violations, they're going to issue citations. That's what happened. It doesn't reflect the actual use of the property. And I don't believe that it would substantiate any kind of vested rights or variance by estoppel argument, which again, I would emphasize that the applicant does not raise.
So Mike, we just heard a lot from Matt. I mean, anything you want to,
Well, first, I think Matt made a point about the no zoning application. There was no zoning application required in 2019. So the fact that there wasn't a zoning application doesn't mean that it was not asked for. It was a permitted use, student housing. They took the step of filing the RRU, which was required then. As for the variance by estoppel, again, I don't know if we actually needed a permit. We didn't get zoning relief. We did to establish the use in 2019. It was not necessary. What I think, the city has argued is that there's no certificate of occupancy. There was no formal zoning approval. We didn't have to get that. It wasn't necessary in 2019. The city did not argue, though, that, and I briefed this issue, that a separate occupancy voided, or lack of a occupancy voided the use, or that even a permit was required to establish the use. It's Article 1739, it regulates through registration inspection, not through zoning. That's the difference there. So the question is, if they started and said we wanted to have student housing there in 2019, 2020, before the ordinance overlay, did that then conforming use now become non-conforming? Was it established? My argument is yes, it was. They took the affirmative steps that were necessary at that time to say, we have this use and we want to use this property as that use. Again, I'll go back. You don't need the kids in the beds. You need the act of filing for the RRU. That's our stance there.
I certainly think that if, for example, they file for the RRU and the city took, like, let's say, an unreasonably long time to process the application or conduct the inspection, and that's what precluded them from kind of beating the clock on the ordinance, there might be some kind of issue there. No one's alleging that that happened. And again, I think if we just said that because in 2019 they submitted an RRU application and that's good enough, even if no inspections are successfully performed, no COs issued, there's no argument that the city unfairly delayed processing it, and just by the virtue of filing that application, they're somehow given non-conforming use status despite never actually making use of the property. That's just not what the law is. And I think if the applicant could support that position, it would be a novel legal position. They would have found some kind of case to support it. Again, with the vested rights and the variance by estoppel, what we don't have is any kind of permit issued and where the applicant relied on it. It's very important. I mean, I laid out in my brief, there are elements of those kind of defenses that are not even asserted here, much less proven. So I think we are just looking at, does he meet the criteria for the special exception, or does he meet the criteria for the variance? And we believe that it's a no on both cases.
I just want to go back to the violations again. Sorry. Because when you,
No problem.
when you laid out like what happened, so like the people go out and look at a record that apparently is not actually a record of the RRUs, but It's how apparently the city identifies what RRUs are and then issues violations against that record.
Well, I guess there are RRUs in C+, and that's what the code people would see if they're issuing citations. I think the citations were for not at some point paying the fee or whatever. I'm not certain about that. But again, it's an issue where the code people are looking at this from a code perspective, and they're focused on Article 1739, not the zoning component of this. And they're going out and they're issuing citations and went to the magistrate, and there were convictions. Again, I don't think you can fault the city if they're assuming based on representations by the applicant that this is an RRU. I also would say one other thing about that, right? RRUs are defined differently in the zoning ordinance from student homes. So it's not really good enough that you just have, even if there was a non-conforming RRU use on the property, which there's not, because there were never 3 to 5 unrelated people living there, that wouldn't be good enough for student home non-conforming use, because you need the added element that they be college students.
But there's no established record in the city of what our RRUs are that have been that are in the student overlay.
Well, RRUs would be 3 to 5 unrelated adults living as a single household unit.
Mike, can I get your response to what he just said there?
Prior to the student housing overlay, and the student housing overlay predicates maintaining your non-conforming use on having an RRU. What I think Attorney Deschler just said is misleading to the extent that you didn't need a zoning permit before the overlay to have student housing in this area.
Isn't there a universe where that your client had a protected RRU, and I'm not saying if they did or not, but they had a protected RRU that had not yet been used for student housing at the moment, or that there had been no application pending at the moment that the student overlay went into effect, where the current pre-existing non-conforming use is an RRU, but not student housing.
Could that be in a universe?
Well, I think it's his argument.
I think when they established the RRU, they were synced. I'll say student housing and RRU were joined at the hip. If they are now, the city's position is they are separated, then I guess you could say that maybe they have an RRU and they don't have a student housing. I don't know how that would change the relief we're asking for, though.
Your relief is for student housing. And the question is, at the date that ordinance went into effect, what established the overlay in 2020, 2021, I don't have the date in front of me. At the moment that went into effect, what establishes the pendency or existence of the student housing as distinguished from the RRU? I know what you're saying is that before that
the ordinance states that you have to have an RRU to maintain a non-conforming student housing use. You had to have an RRU prior to the establishment of the overlay district.
Yeah, you're saying they were one and the same.
They are.
Right. And I did address this in my brief. So if, for example, you had 3 to 5 college students living at the property, say in 2020, right, they'd be residing there as a regulated rental unit. And I would acknowledge that if they continued to reside there after 2021, they would be residing there as a non-conforming student home, right? But it matters, the content of the people living there matters. So you could absolutely have an RRU of 3 to 5 unrelated adults living there. And that if they were still living there, right, that would have non-conforming use status as an RRU. But to have non-conforming use status as a student home, back in 2019 or 2020, you would need the 3 to 5 individuals to be students, right? So in 2019, they'd be an RRU just as if they were not students. But to get the non-conforming use status, it does matter about the content of those individuals. So you could have a situation absolutely where 3 to 5 unrelated non-college students who were living there 2019, 2020, 2021, 22, they had non-conforming use status as a regulated rental, but not as a student home. Whereas if you had 3 to 5 college students living there 19, 20, 21, 22, they would have non-conforming use status as a student home.
All right, any other questions from the board?
Can I have one more, and I hope to be quick, but I honestly keep going back because I think you even said it yourself that at one point this was an RRU, right? And then so we keep going back.
No, like I want to be very clear. I have never said that, and I would never say it because it was never an RRU, because it was never either occupied as an RRU, nor was it ever approved as an RRU. This has always been a single family residence. The Borsos lived there forever, and then Kathleen Borso lived there by herself until 2024 when she passed away. So
Okay. It might have been a slip of your tongue, but as of 10 minutes ago, you just said at one point the city designated this as an RRU.
No, it's reflected in their records as an RRU because the applicant represented. But I think that matters. If they tell us it's an RRU, and that's how it gets into our records, I think that's a difference from the city actually affirmatively saying we've made a finding that this is an RRU when it was never. And again, I take it back to the point where it's the use that matters, that it was never actually an RRU.
Yeah.
Sorry.
I mean, we might.
splitting hairs there a little bit because they've treated it like an RRU. They find it like an RRU.
Yeah, that's the point of my problem, and I've expressed that right away. So, I honestly think we go back to the word abandon, right? Like that's what I keep kicking around in my head. That like I truly think that the city has said that this is an RRU, if I'm being honest. But then again, I go back to that like it never passed a CO, and there's the whole 12 months thing that we kind of spoke about. And I would just like to hear your thoughts. Like if that is like convince me if that is where I am in my mind, that then this is now an abandonment, because once again, you said you don't have kids in the beds.
Right. Okay. Can I just ask a question to clarify? Right.
Sure.
So you have a house, right?
I do.
How do you make use of your house?
I live in it.
Okay. What activities do you do in the house?
Sleep, eat, cook, do the things.
I noticed that among those activities, you didn't say it's registered as a house in the city's C+ records, right? And I'm going to keep coming back to this because I really think if we're going to apply the law here in a rigorous way, then these concerns about did the city treat it as an RRU are totally irrelevant unless someone can come up with a case that says it's true. Otherwise, we look to the actual use of the land. And I just point to the applicant's own witnesses who say it was never used for students, never used for 3 to 5 unrelated individuals. And that's the ball game. So I don't really, I mean, I think I've addressed these issues about how the city's records reacted to the applicant's representations. But ultimately, if we're doing what we're supposed to do here, we have to look to how the property was used, not how it's reflected in record. And I would also say that to address that kind of issue, like sometimes you can get relief if the city has like erroneously done something like issue a permit in error and the applicant relies on this. And that's how they achieve relief in the way that you're saying.
Mhm.
But I would really emphasize here that the applicant has not made those arguments. And they have not shown, as I've laid on my brief, for vested rights or variance by estoppel, they have not met those elements. If they can't meet those elements, they're not entitled to relief that way. That's the only way, to my mind, that the issue with what's in the city's records actually matters. They can't actually show those defenses. They don't even try to show those defenses. They mount an argument with no supporting case law. They just want you to accept it. What I'm saying is, and I've pointed to case law, that what matters here is the actual use of the property, not what's in the records, unless they can establish that those records matter because they can show the elements of those equitable defenses, whether it be variance by estoppel or vested rights. They can't, they don't even try.
Like any response, especially relative to abandonment?
Well, I don't think it was abandoned. I think the use was established. I made the point 3 times. The zoning officer agreed with me in June of 2025 based on his own analysis. It was only after they applied for an expansion that they determined, oh, this is not a non-conforming use at this point.
Any other questions from the board?
No.
All right. So for the members of the general public, remember, this is legal argument. We don't need testimony. We know there's disputed facts. All right. This is solely for legal argument. I would like to say to both counsel that was capably argued. It was extremely well briefed by both sides. I think the board has heard the comments. I think the audience has heard the board's positions. But if there's any legal comment, is there anyone, raise your hand if you feel any legal argument that anyone wants to make? All right. So for both parties, again, thank you so much. It was well argued, well briefed. The board will currently table the matter. We'll take action on it at the end of the meeting tonight. Attorney Raschuti will communicate with you as soon as.
Thank you.
He can. Safe travels.
Thank you.
We don't do one thing now and then tell them.
What?
That's
No,
No.
we're gonna do that
That's the
after
next-
this next one.
I thought there was like a two-step process, that it was like.
No, that's
No,
next.
the next.
That's next.
next.
Yep. All right, so that concludes that matter. Move on to number 2.
All right, number 2, 867 East Makeda Road.
867 East Makeda. Sorry. 867 East Makeda Road. Applicant Clifford and Jane Cummings appeal a determination of the zoning officer that a proposed second dwelling unit located in a detached accessory structure is not permitted. Alternatively, applicants request a variance to permit a second dwelling unit in the detached accessory building. Zoning ordinance sections 1302.02, 1302.40A, 1302.41, 1306.01A4, 1318.02, 1325.05, 1325.06, and all associated variances, special exceptions, and interpretations.
And can you confirm when you posted the property?
When was the property posted? Posting of the property. When was the property posted?
When was the property posted?
The notice, the yellow card on the property.
Yeah, the 2nd of June.
The side, for the record, I heard the 2nd of June. Attorney
It was the
President.
2nd of June, and that is Dr. Cummings. He's owns the property along with his wife who's seated there with him.
And I can confirm that Dr. Cummings sent me an email with photographs.
So Attorney Preston, I explained to the board that you'd like to bifurcate the hearing tonight in terms of the variance and the interpretation.
Yes, we've done that by agreement with the city.
So why don't you just tee it up for the board exactly what we're here for tonight, what the relief is as a whole, and then we can move into the variance.
You want to hear it? You want?
Yeah,
both of them?
just generally what's the whole story tonight?
Sure, absolutely. So Dr. Cummings owns a property in the city of Bethlehem. The deed to the property indicates that it contains 3 lots. And the 3 lots
Go
are
to the
now,
microphone.
oh, sorry.
Thanks.
And the 3 lots are now on a single deed. The gross acreage for the property is, I believe, 55,000 and some odd feet. And on the property is his residence. At some point, he submitted an application to build a garage, which would be an accessory structure to his home. That's a separate detached building, not attached to it, but as a separate building. The city had processed that application and granted a permit for him to construct this accessory structure. Somewhere during that process, working with his architect, John Lee, who's seated here to my right, Dr. Cummings decided or determined that he would like to have living quarters above the garage. So they converted the upstairs to what would be a dwelling unit as defined by your ordinance, as you know, the kitchen, bath, cooking facilities, those types of things. And that, I believe, would run afoul of a ordinance provision which specifically prohibits dwelling units being built above or upon detached accessory structures. We don't deny that the ordinance says that, and we're not really arguing that we are in conflict with that. Where this gets a little more interesting is the size of the lot. So your ordinance allows, as you know, and more than one principal use on a lot. The principal uses, however, must meet each of the uses on its own must meet the dimensional criteria that the ordinance requires for each of those uses. Because Dr. Cummings' lot is a 3-unit, 3-lot parcel and contains over 55,000 square feet, he has enough square footage under your ordinance to put 3 individual single-family dwellings on that lot. He can do that. That's our position. So what started out as the garage as an accessory structure with a dwelling unit atop of it We then resubmitted an application for not a garage, but a single-family dwelling. So we would have two single-family dwellings on the property as opposed to one single-family dwelling, a detached garage with an accessory dwelling unit on top. What we would have is the existing single-family dwelling and a second single-family dwelling. You wouldn't be able to do that on most lots in this district because they don't have over 55,000 square feet. You could do it with this one. Now, the city refused, when we submitted our application for single family, it went to the zoning department. They crossed off single family. They made some other changes to the plan that we submitted and said, no, this is a dwelling on top of an accessory structure. We said, well, no, these are two independent single family dwellings. They meet all the definitions in your ordinance and they meet all the lot sizes. So there's no reason why they're not two single family dwellings. We have agreed, Mr. Deschler and I, to approach this from two different angles. The first would be we would accept their definition that it is a detached garage with a dwelling unit over top of it and request a variance from the provision that prohibits dwelling units over garages. In our case, we base mainly on what I just told you, the areas, those types of things, and we would respectfully request a variance. That would be the first part of the presentation. Failing that, then we would move on to what I'm calling the interpretation, which is what we've asked for in the application, and we would present evidence to confirm. We present the deed, we present the tax records, we would confirm the acreage, we would confirm that this second building is in fact a single-family dwelling with a garage, and it meets all the definitional criteria. That the ordinance does permit more than one principal use on a lot. I've had this issue with this board where I've been denied because we don't meet the tract size. We don't have the cumulative tract sizes. We have way more than the cumulative tract size for two single-family dwellings on a lot. And so we would request an interpretation that this building, this new building, does in fact meet the definition, the ordinance definition of a single-family dwelling, and that it is permitted on the lot as a second principal use, and that it meets all the dimensional criteria for a second principal use single-family dwelling on the lot. Again, going back, Mr. Deschler and I have agreed to approach this, the variance first, with the understanding, the agreement that we will operate from the perspective of it being a detached garage with a accessory structure above it. Is that correct, Madam? You go ahead and you can add to that, or
Should be working.
I assume Dave, the blinking red light means that it's.
Okay, I see a green light from,
I feel very confident you're being heard online.
Yes, the city is unopposed to the variance requested, and only unopposed to the objective of the variance.
So one little bit of housekeeping, just because we want to be very clear on this. So Mr. Schneck, I want to address the issue that you wrote down on a piece of paper. Mr. Schneck has a pet of some type, and Dr. Cummings is Mr. Schneck's veterinarian. Out of an abundance of caution, he wants to disclose, Mr. Schneck, you can be fully non-biased relative to this matter, correct?
I can.
So we just want to disclose that there is I wouldn't call it a personal relationship, but he just,
I understand.
Out of an
Is your pet in good health?
He did an amazing job, and she just turned 17. So thank you very much.
so
I might have an issue.
Mr. Schneck, just as you know, there's these personal relationships. Sometimes we just wanted to throw that out there. Good. Attorney Preston, it's all yours.
Okay, very good. Then I'm going to call, just for purpose of expediency, let me start with Mr. Taylor. Okay, so Mr. Chair, I think, have you been sworn?
I have.
Okay, very good. And you're the zoning officer for the city of Bethlehem?
I am.
And how long have you been the zoning officer?
I believe since September 2024.
And you've been the zoning officer throughout the pendency of this application, is that correct?
Yes.
You're familiar with the city's involvement with this application?
Yes.
So when the application first came in, it was, I believe, to build a garage, a detached garage that would be accessory to an existing home. Is that correct?
Yes.
On the property owned by Dr. Cummings and his wife, is that correct?
Yes.
And that permit was approved?
Yes.
Okay, and then at some point, did there come a time when another application was submitted for, in lieu of the garage, for a single-family dwelling?
I recall that it was to put a dwelling above the garage. I don't recall specifically.
That's fine. I'm not trying to trick you or trap you. So a second application came in for something which you're not sure of. That application was not approved as it was submitted. Is that correct?
Correct.
And I believe you heard my opening. It's the city's position, I believe, that the original application, which was for a detached garage, controls. Is that correct?
Correct.
And so that if you want to add the dwelling above it, it can only be as an accessory to that garage. Is that correct?
The dwelling would be going into what it was approved as an accessory structure.
Okay. And the lot size of over 55,000 square feet, are you familiar with the size of this lot at all?
From reviewing plans, yes.
Okay, so let me ask you a hypothetical. Let's say we ditched the garage, no more garage, we got rid of that. And Dr. Cummings said, you know what, I have a different plan. I want to come in and I want to put a single-family dwelling, a second single-family dwelling on this lot. Is there a prohibition on that, just putting a second single-family dwelling on that lot? Let me rephrase that. You can have more than one principal use on a lot, isn't that correct?
You can have more than one principal dwelling on it, more than one principal use on a lot.
And that would include more than one principal dwelling.
Aren't we addressing just the variance now? Are we getting Mr. Taylor's?
Well,
interpretation?
I think what I'm trying to, and Jim, you can speak to it. I think we need to understand what sections we're seeking relief from. Is that where you're going, Jim?
Yeah.
Yeah.
So,
But Matt, please feel free to object if he feels going towards the interpretation.
okay, now, well,
Well, let me say this. Is there agreement on council on what we're seeking relief from?
I think, can I just have a moment?
Oh, good.
I don't mind doing this on the record. In order to, I think, validate the variance, I would have to show some type of a hardship. The hardship, the only one that I could come up with is that we would ordinarily be entitled to do one thing, but this interpretation limits us to doing something else. So we're asking for a variance that would result in something that we might otherwise be allowed to do.
Matt?
I mean, can we say that it was Mr. Taylor's determination that the applicant was not permitted to
Modify?
convert what had been?
Modify?
Yeah, into
Okay.
single-family dwelling?
I'll roll with that. That's good. So it was your determination that the applicant was not entitled to modify that original application in a way that you felt violated the ordinance.
Correct.
Okay. And that's the reason that we're here this evening.
Yes.
Okay. I have nothing further for Mr. Taylor. You're up. Okay, then I'm going to call John Lee. Have you been sworn?
Not tonight.
Let's get everybody sworn.
do-
Stand up.
Does the board, the board's asked if they have questions for Mr. Taylor. Are you have questions for Mr. Taylor?
Yeah, I mean, I'm just gonna ask this basically. It's like, so is it true that there's enough space to build a second single-family home there?
There is a requirement for a minimum of 15,000 square feet for a single family dwelling
Which they-
per dwelling unit, and the lot does exceed that. Yes.
Thank you.
Is that all, Lucas?
Thanks.
Sorry, Jim, didn't mean to interrupt.
That's all right. We have some swearing in to do, I think. Ron, stand up, Ron.
You do swear or affirm that the testimony which you shall give in the matter now before this board shall be the truth, the whole truth, and nothing but the truth. You do so swear or affirm?
Okay, so this gentleman seated to my right is Mr. John Lee. John, would you identify yourself for the record, please?
John Lee, Lee Architectural Associates, been in business since 1994 as
You're-
a registered architect.
And you're familiar with the property or the appeal that's before the board this evening?
Yes, we produced the drawings for this project and other projects at this residence, yes.
So the initial submission for this project was in fact for a detached garage that would be accessory to the existing home. Is that correct?
The initial
Sorry,
submission,
I'm having
several,
trouble hearing you.
Okay.
yes, the initial submission was made several years ago as a garage.
This has been kicking around for quite a while.
Yeah.
Okay. Now-
Almost 2 years, maybe?
That's fine. The deed for the property, and I'm going to mark this, we'll mark this as A1. You've seen the deed to the property before, have you not?
Yes, I have.
And does the deed to the property confirm that it's an amalgamation of 3 individual lots?
Yes, lots 1, 2, and 3.
Okay. And let me do this here. Let me get my hands on the tax record. This is a copy of the county tax records for the property. And take a look at that. And on there, does that confirm the acreage that we're dealing with here?
Yes, 1.28 acres.
Okay. And I did the math. I came out with 55,000 and change. You want to do that for us real quick? 55,756.8 square feet. Am I remotely close?
Uh, 55,756.8
Square feet.
square feet.
Okay, I'll have this marked as A2. That is a copy of the county tax record. Then, let's see here. So the original plan that was submitted, at some point, did you have conversations with your client, Dr. Cummings, about doing something different with that building?
Yes, he wanted to be able to convert it the second floor and show a apartment up there, a residence up there, and then his son was going to be using the garage and the residence above
Okay,
as a single family home.
okay. And did you then resubmit or did you submit a new plan for the new proposal?
A new plan was submitted, yes.
And did that plan identify itself as a plan for a single-family residence?
Correct.
And what happened to that plan? Well, I'm sorry, was that plan submitted to the city?
Yes, this plan was submitted to the city. I did not make the submission. I believe Ron submitted that plan.
Yeah.
Sorry,
Builder.
you
Hold
need to
on.
speak into the microphone.
One at a time, one at a time.
Yeah. It was submitted
on,
by
time.
the builder.
Okay, fine. So the gentleman you spoke about, Ron,
Yes,
he's the builder?
yes,
He's seated here this evening?
correct.
Okay. Now, what's in front of you now, if you recognize that?
What's in front of me now was the drawings that were produced for the single family residence and showed the conversion or the revision of the second floor into a residence.
Okay, I'm going to mark that as A3. Now, what's in front of you has an awful lot of red markings on it.
Yes.
Are those yours?
No, those are red marks produced by the city and titles here, Bureau of Inspection, City of Bethlehem.
Okay, and I see they've crossed out your title of single-family residence.
Correct.
They've replaced it with a new title.
Yes,
What
it
does that
says
say?
accessory space with convenience powder room only.
Okay,
Not sure what that means, but, and then the second page has X's across the living and kitchen area and the bedroom. And then the third page, there are no markings on the third page. That is just elevations of the structure.
okay. Now, the unit that's been proposed for the second floor
Yes,
on this plan calling for a single-family dwelling. The dwelling unit upstairs on the second floor, would you consider that to be a single habitable living unit occupied by only one family?
Absolutely. It has a full bath, shower, sink, and toilet, has a full kitchen, living area, separate bedroom with closets.
Sleeping areas, bedroom, going down, hold on. Does it have separate access to the outside or a common hallway or balcony that connects to the outside at ground
Correct.
level? And there are no, let me see, there are no two or more separate living areas that are completely separated by interior walls so as to prevent interior access from one living area to another. We don't have that condition.
We don't have that. We have a separate entrance directly from the outside or directly from the garage itself.
Okay, now I'm going to hand you the ordinance. I'm going to ask you to take a look at section 1302.40, which is titled dwelling unit. Just take a minute and look that over and tell me if that's what's being proposed for that second floor.
Yeah, that's exactly what's being proposed in this ordinance. It talks about to be considered a dwelling unit. Each dwelling unit shall have its own toilet, bath, shower, check mark, sink, sleeping, cooking facilities, check, check, check. Separate access to the outside or to common unit. We have outside access directly from the exterior and also from its own garage underneath. There is no second unit. There is no second kitchen. There's nothing of the other stuff that would negate any of that. So we clearly are defined by as a dwelling unit.
Now, I'm going to same ordinance. We're going to take a look at 1302.39, which is entitled dwellings. And subpart A identifies something called a single-family detached dwelling. Okay, take a look at that. Read that. In fact, read that. It's only one line. Read
Yeah,
that.
it's a building occupied by only one dwelling unit, which we have, and having no party wall in common with adjacent building. We're completely separated from any adjacent building.
So do you believe that we meet the definition of a single-family detached dwelling?
Absolutely, yes.
Now, but for the fact that we are, at least under this initial scenario, attempting to attach this to an accessory building, we wouldn't really have a problem, would we?
None, no.
No. In fact, you're familiar with the issue that we talked about earlier, which is that you have to have a certain minimum tract area.
Right, 15,000 square feet. We have almost enough for 4
Single-family dwelling.
single-family dwellings. We would need 60,000 for 4. We have 55,800, whatever.
Okay, so but for the complication of that, the application of that definitional section, we, in your estimation, be free and clear to do what we
That's
have proposed to do.
pretty clear in the zone, in the ordinances.
I have no further questions for this witness.
Just a quick clarification for Mr. Taylor. So if they demoed the garage, so the garage doesn't exist, and came back and were building the single family,
I would want to fully review the application.
all right, that's all.
Mr. Preston, do you have a response on that?
I couldn't hear what this,
Oh, I asked if you guys demoed the
I
garage.
heard the question. The answer
Oh.
was,
I would want to fully review the
He
application.
doesn't want to answer hypotheticals, what he
I
said.
got you. Understood. Okay.
I have one more quick. Is there space, if you were not building on top of this, is there space to just build a full other single family dwelling unit that is not on top of this garage?
There's room to build, I think, at least one more
Mm-hmm.
and maybe 2. 55, 40.
Just, we could build one more.
In addition to this. So the
We'd have an
existing,
extra 10,000 square feet.
the existing dwelling would be 1.
Mm-hmm.
This would be 2 if we're allowed to do this. Then we'd be able to put a third
Mm-hmm.
based on what's remaining.
But hypothetically, like the counter argument to the hardship in my mind is saying you don't have to build on top of the garage. You have enough space to just build it in the separate lot. Keep the garage as is
Mhm.
and just build it right next to it. You guys have the space to do that, right?
There's the space to do it, but there's a certain economy of doing it all at one,
Sure.
over that
Exactly. Yeah. Okay.
one section there.
So for me, the only relief you need per the direct testimony is 130202. The definition of accessory building says at the end that it may not,
Yes, that's the section.
so if the board is to grant relief, that is the section we will grant relief to.
Yes, we would be allowed to, if the board were so inclined, allowed to place a dwelling unit in combination with that accessory garage.
Okay.
Which we
And-
believe is really just a dwelling unit.
And Attorney Deschler, you said the city has no argument against that as a variance.
The city is not opposed to the variance.
Okay.
The city's not taking a position. The city's not taking a position one way or the other on the variance.
All right.
Other questions from the board? Audience.
Any questions from the audience? Any other witnesses?
I have nothing further. Move for the admission of the exhibits.
Jim, I actually never got your exhibits, the ones you were marking.
Yes, I'll get them up to you.
Yeah, if you don't mind.
Yep.
I think we have them in the pack, most of them in the packet, but
Any comment from the public?
Okay, A1,
All right,
A2.
we go off record.
we'll be outside.
Here you go. I got them marked right here.
Now the surprise is spoiled.
Microphones are back. Sorry.
Okay, good.
All right, at this time, we'll go back on the record, and if I can have a motion from a member of the board.
Sure. I'll make a motion to grant the variance as presented.
I will second that motion.
Mr. Schneck,
Yes.
Ms. Wiles Young,
Yes.
Mr. Walk.
Yes.
Thank you.
Variance is granted unanimously.
Written decision will follow, and we thank you for your time.
Thank you.
With that, can we have a motion to move into executive session to deliberate on 436 Terrace?
I will make that motion.
Second.
Oh, yeah.
Mr. Schneck,
Yes.
Ms. Wiles Young,
Yes.
Mr. Walk.
Oh, yes.
So we're off the record and we'll be in executive session. We're on. So the board would like me to articulate a motion. It would be a motion to deny recognition of the pre-existing non-conforming use as student housing. Is there a motion for that? Or does someone make that motion?
Yes, I make a motion to deny.
Is there a second?
Yes.
Dave, can you call the roll?
Mr. Schneck,
Yes.
Ms. Wiles Young,
Yes.
Mr. Wolk,
No. I'm going to make a request that the solicitor draft an opinion to specifically note my dissent. I honestly do not think that the city should have issued these violations. And I think by issuing the violations, I believe that the city acknowledged that this was established as an RRU at one point. So, thank you.
Been hearing that instruction. And next would be a motion to deny the variance as requested.
I'll make a motion to deny the variance as requested.
I will second that.
Mr. Schneck,
Yes.
Ms. Wiles Young,
Yes.
Mr. Wolk,
Yes.
All right, Matt, as you know, the city will issue, the zoning hearing board issues its decision. And any appeals can be filed at the Court of Common Pleas, although you won, so you're not going to file an appeal. Attorney Raschuti is not here. We'll communicate it to him.
you know. Meeting is adjourned.